imagine an office building just, completely collapsing. And not from like an explosion or a seismic event, but because someone removed a single screw on the 12th floor.
Right, just one tiny piece of hardware.
Exactly. Well, welcome to today's deep dive, because in the world of Ontario employment law right now, that little screw is a missing comma on page 12 of a corporate HR handbook. And it is actively costing companies hundreds of thousands of dollars.
Yeah, it's a pretty chaotic time for employers, to say the least.
It really is. So for you, our favorite perpetually curious listener, our mission today is to figure out exactly how these seemingly tiny corporate HR mistakes, like a standard run-of-the-mill vacation policy, can suddenly trigger this massive financial destruction in 2026.
Because the environment right now, in the mid-2020s, it's culminated in this extraordinarily restrictive landscape for employment agreements.
Right.
Like the days of companies using those broad, standardized templates with, generalized language to cheaply limit their liability, those days are completely over.
They're just gone. Okay, let's unpack this. All of our insights today come from this fascinating 2026 legal brief by Tony Wong at HTW Law Professional Corporation. It's titled Navigating Ontario Employment Law in 2026.
And it is quite a read.
It really is. And reading through it, it seems like to understand how these legal bombs are detonating, we have to start with this surprisingly misunderstood concept, which is vacation.
Yeah, vacation, which sounds simple, but under the Ontario Employment Standards Act, the ESA, it's actually a critical statutory bifurcation.
A bifurcation, so meaning it's split into two things.
Exactly. The law dictates that vacation is not just, one single amalgamated benefit. It's two entirely distinct parallel legal entitlements. You have vacation time and you have vacation pay.
Okay, break that down for us.
Sure. So first, you have vacation time, which is the physical absence from the workplace. It's your legal entitlement to literally disconnect for rest and recovery.
Which we all desperately need.
Right. I mean, burnout is real. And the statutory minimum here is 2 weeks off for employees with less than 5 years of continuous service. If you have 5 years or more, that minimum automatically jumps to 3 weeks.
Okay, I like to think about this like a hotel reservation. The vacation time is like the physical room you are assigned to sleep in. You have to actually physically go there to fulfill the reservation.
That's a great way to look at it, because completely parallel to that room reservation is the vacation pay. And that is a purely monetary entitlement.
So the money to pay for the room.
Essentially, yes. It functions as deferred compensation so that the employee doesn't lose their standard income while they're, resting in that hotel room.
Right, makes sense.
And this is calculated strictly as a formula. It's 4% of gross wages for those under 5 years of service and 6% of gross wages for those with 5 years or more.
And I noticed in the brief, the definition of gross wages seems like a pretty immediate trap for companies. Like it's not just your base salary, is it?
Oh, not at all. Gross wages explicitly includes your regular salary, plus non-discretionary bonuses, overtime pay, and crucially, all commission earnings.
Wait, all commissions?
All of it. So if you have a top-tier salesperson pulling in massive commissions, their mandatory vacation pay is 4% or 6% of that entire combined pool.
Oh, wow. So it's not just their base.
Nope. And companies constantly miscalculate that number because they just base it solely on the flat salary.
Okay, but from a business perspective, I have to push back here for a second. I mean, isn't it infinitely easier for companies to just bundle this all up?
What do you mean?
Well, if an HR manager just says, here is your paid time off, go enjoy it, why does the law care if they're separated on a ledger, as long as the employee gets their money and gets their time away?
Well, what's fascinating here is that because they are parallel legal entitlements, treating them as a single generic benefit is exactly what creates the fatal drafting errors we're about to explore.
Okay, how so?
Because you cannot satisfy a legal requirement for physical rest with money. And you can't satisfy a monetary entitlement just by telling someone to stay home. They are distinct obligations. They have to be tracked separately.
Right.
So if an employer's contract blurs them together into one generic bucket of, paid time off, they expose themselves directly to the forfeiture dilemma.
Okay, forfeiture. So if they're parallel entitlements that can't be blurred, what happens at the end of the year when an employee just hasn't used either?
Well, that's the big question.
Right, because can companies just sweep that unused time and money back into the corporate coffers to balance the year-end books?
Yeah.
This brings up the classic use it or lose it policy.
Yeah, and the short answer is absolutely not.
Yeah.
The ESA minimums are strictly untouchable. You are unequivocally prohibited from forcing an employee to forfeit their ESA mandated minimum vacation pay so that 4% or 6% and their minimum vacation time.
Never.
Never. A company can only apply a forfeiture rule to contractual extra vacation. The brief actually lays out a perfect scenario for this.
Well, let's hear it.
Imagine a company courts a senior executive and grants them, say, 6 weeks of paid vacation in their contract. The law says the first 3 weeks of that are the untouchable ESA statutory minimums.
Because they have over 5 years of experience, right?
Exactly. So only the remaining 3 weeks are classified as contractual extra vacation. So a use it or lose it policy can legally only apply to those extra 3 weeks.
Okay, but what if the employee just stubbornly refuses to take the physical time off? Like, let's say they're a total workaholic. They just refuse to leave their laptop. Do you just pay them out for the time they didn't take and call it a day?
Nope. Converting statutory time into a payout just to avoid the physical break is completely illegal. Taking vacation time is a mandatory statutory requirement. It is not an optional employee perk.
Wow, really? So it's not up to the employee?
It really isn't. The legal burden of compliance rests squarely on the employer. If the employee neglects, refuses, or just forgets to schedule their statutory vacation, the employer has the legal authority and the statutory obligation to force them to take it.
Forced relaxation.
Literally, yes.
Pack your bags, Dave. You're legally required to go to the beach, and if you don't, the company is breaking the law. That sounds so absurd in a modern corporate culture.
It does sound absurd, but the law takes it very seriously. It dictates highly specific rules about how you force that time. Like, when you mandate the schedule, you have to adhere to strict statutory block scheduling rules.
What does that mean? Block scheduling.
It means a single, uninterrupted 2-week block, or 2 one-week blocks. You are strictly prohibited from forcing an employee to take their statutory minimum vacation in single-day increments.
So you can't just be like, take every Friday off for the next few months.
Exactly. Not unless you have a specific written agreement with the employee to do so. And this isn't an open-ended requirement either. The statutory deadline for completing this mandated vacation time is exactly 10 months following the end of the entitlement year.
10 months. And what if they miss that?
Miss that deadline, and the employer is in technical breach of the time provisions, though they still owe the accrued pay as a lump sum.
Okay, so let's tie this together. An employer accidentally sweeps up those untouchable ESA days into a standard use it or lose it policy. What is the actual fallout? Why does a sloppy vacation clause matter if, say, an employee is getting fired for poor performance anyway?
Oh, this is the multi-$100,000 mistake.
Here's where it gets really interesting.
It really does. So there's this foundational 2020 appellate precedent called Waxdale versus Sweagon North America, Inc. And it fundamentally altered how courts view employment agreements.
How so?
It introduced the doctrine of contractual indivisibility, meaning an employment contract is no longer just a list of independent terms. The courts now read it as a single connected ecosystem.
Oh, so it's like a single line of corrupted code that crashes the entire operating system. You can't just isolate the bad parts anymore.
That is the perfect analogy. So let's apply that to the sloppy corporate handbook that broadly states all unused vacation is forfeited. Exactly. The court scrutinizes it and determines that, theoretically, this forfeiture clause could result in an employee losing even 1 day of their ESA mandated vacation pay. Therefore, the entire clause is illegal.
Even if it's just theoretical.
Even if it's purely theoretical. And because of contractual indivisibility, that illegal vacation clause infects the entire ecosystem. The immediate devastating consequence is that the employer's carefully drafted, entirely unrelated termination clause is struck down in its entirety.
Wait, really? The termination clause?
Yes. It becomes void ab initio, meaning void from the beginning.
Okay, let's walk the listener through the actual math on this, because the financial devastation here is staggering.
Yeah.
The primary purpose of a termination clause is to limit the severance an employee gets to the rigid ESA minimums, right?
Right. And those minimums are capped at a maximum of just 8 weeks of notice, no matter how long you've worked there.
8 weeks.
Yeah.
But when that termination clause is voided by, your vacation policy error,
you are instantly stripped of that protective statutory shield. The severance entitlements automatically revert to something called common law reasonable notice.
and what does that look like?
While common law severance frequently averages approximately 1 month of full compensatory pay per year of service, up to a massive ceiling of 24 months.
24 months. So what does this all mean for the listener? It means a lazy HR template about taking your vacation days can directly result in a company paying out hundreds of thousands of dollars in unanticipated common law severance when they fire someone.
Yep, the difference between paying 8 weeks of severance and 2 full years of severance, all because of how you worded a completely unrelated vacation policy.
That is terrifying. But historically, corporate lawyers built firewalls into contracts to protect against this exact domino effect, right?
They did. They utilized defensive drafting mechanisms that worked for decades. But if we connect this to the bigger picture, recent case law, specifically coming out of 2025, has essentially burned those tricks to the ground.
Which the brief calls the 2025 Baker paradigm.
Exactly.
I want to understand the why behind this shift, though. Why are the courts suddenly so aggressive about finding these contracts void? Have they just decided to be, like, unilaterally pro-employee?
Well, the courts have acknowledged a massive inherent power imbalance between employers and employees during the hiring process. I mean, when an employee signs a contract, they rarely have the leverage to negotiate standard HR boilerplate.
Very sure. You just sign it to get the job.
Right. And for decades, employers would draft incredibly restrictive, sometimes borderline illegal clauses, knowing the employee would just sign it. If a dispute arose, the employer would just point to a saving provision.
A saving provision. What is that?
It was a generic clause at the very end of the contract, basically stating, in no event will the employee receive less than their minimum entitlements under the ESA. It acted as this magic legal shield.
So the employer could put whatever intimidating language they wanted in the contract to scare the employee, and if they got sued, they just shrug and say, whoops, look at paragraph 50, we default to the legal minimums anyway.
Exactly. But the courts finally decided that was unacceptable. In the 2025 decision, Baker versus Van Dolder's Home Team, Inc., the court explicitly ruled that a general saving provision can no longer magically shield a poorly drafted contract.
Wow, so the magic shield is gone.
Gone. If your vacation clause allows for illegal forfeiture, a generic saving clause at the end of the document will not save your termination provision. The courts are forcing employers to draft flawlessly from day one. They can't rely on a safety net to catch their intentional overreach anymore.
I imagine this logic also applies to the classic at any time conundrum. A lot of older contracts state an employee can be terminated at any time. That seems standard, but I imagine saying at any time gets you in trouble because there are obvious legal exceptions.
Huge trouble.
Like you can't fire someone for going on maternity leave or taking sick time. Does the court penalize the company just for using that broad phrasing, even if they aren't actively trying to fire someone on medical leave?
They absolutely penalize the company. Stating you can fire someone at any time actively conflicts with roughly 47 separate statutory prohibitions against termination under the ESA.
47.
Yeah. As you noted, you cannot fire someone while they are on a protected 27-week medical leave, or as an act of reprisal for asserting their workplace rights. Baker cemented the rule that this theoretical overreach renders the termination clause completely void.
So again, the court doesn't care if the company behaved perfectly in reality. They care that the contractual language theoretically permitted an illegal act.
Precisely.
This sounds incredibly punishing for anyone trying to draft these documents. I mean, the courts are leaning heavily on the doctrine of contra proferentum, which essentially means that any ambiguity in a contract will be interpreted against the party who drafted it.
Which is almost always the employer.
Right. And the 2025 case of Brocklehurst versus Michael Companies really highlights this perfectly.
Oh, Brocklehurst established a terrifyingly high bar for clarity. The court ruled that even a minor grammatical error, specifically a single missing comma, failed to establish the high level of clarity required to contract out of common law entitlements.
Wait, a single missing comma?
Just a comma. Because of that missing comma, the termination clause was deemed ambiguous and thus entirely struck down.
So a single missing keystroke equals 24 months of severance. That brings us right back to our collapsing building analogy.
It's also about the precise phrasing of limitations, right? Like in the Movati Athletic versus Bergeron case.
Yeah, Movati tackled a very common HR phrase. The contract stated that in the event of termination, the employee would be paid pursuant to the ESA.
Sounds reasonable.
You'd think so, but the court ruled that was insufficient. To successfully limit liability, the employer must use explicit, exclusionary language. You must state that severance will be paid only pursuant to the ESA.
Oh, just missing the word only. Right. If you leave out the word only, You fail to explicitly oust the employee's common law rights, and the courts will resolve that ambiguity to the employee's maximum financial benefit.
Unbelievable. It feels like companies might try to innovate their way out of this compliance nightmare by using, new corporate structures or trendy perks. For instance, what if an employer just hires someone for a fixed 2-year term?
Like a fixed contract.
Yeah. If there's an end date on the contract, does that bypass the common law ceiling?
Attempting to use a fixed-term contract right now is incredibly dangerous. The 2024 case, Copel versus Lusani Homes, addresses this directly. If an employer includes an invalid early termination clause in a fixed-term contract, perhaps because it was infected by a sloppy vacation policy, the blowback is immense.
Oh, bad.
Well, if you prematurely fire that worker, say 6 months into a 3-year contract, you don't just owe them reasonable notice. The voided clause means you owe them the compensation for the entire remaining balance of the contract.
So you owe them 2.5 years of full pay, regardless of what happens next.
Crucially, yes, and you owe it to them with absolutely no duty to mitigate.
No duty to mitigate.
Meaning, even if the employee gets a new, higher-paying job the very next day, you still have to pay out the entire remaining balance of the fixed term.
Wow. Okay, what about the trendy tech perk of unlimited PTO? Because if an employer's policy is that vacation time is unlimited, they aren't capping anything and they aren't forcing any forfeiture, does that solve the vacation compliance issue?
Actually, it creates a massive hidden liability.
Yeah.
Remember our foundational point. Vacation is both time and pay, and the ESA minimums are untouchable. A policy of unlimited time off does not absolve the employer of their statutory duty to ensure minimum compliance.
So they still have to track it.
Exactly. Employers must still actively, meticulously track employee time to empirically prove that the worker took their physical rest and received their corresponding 4% or 6% vacation pay. You cannot just declare it unlimited and wash your hands of tracking it.
And if you don't track it,
If you can't produce the data proving they took their mandatory time, you could owe them years of back pay when they leave.
that's a huge trap. And because we are navigating 2026, AI is everywhere in the workplace. If the contract ecosystem is this fragile, how do AI, confidentiality, or intellectual property clauses fit into this whole Waxdale domino effect?
Well, employment contracts now must clearly define who owns AI prompts and the resulting work products, explicitly assigning that intellectual property to the company. Plus, employers are drafting incredibly strict confidentiality clauses to prevent employees from inadvertently leaking sensitive client data into public large language models.
Right, but how does that trigger the domino effect?
Because of how aggressively companies are drafting these AI protections. If an employer drafts an AI confidentiality clause that is too broad or attempts to impose illegal or unconscionable penalties on the employee for an AI data leak, the court could deem that specific clause an invalid restraint of trade.
Oh, I see where this is going.
Yeah, because of contractual indivisibility, that overzealous AI clause immediately infects the entire ecosystem. It voids the termination provision, and once again, you are staring down the barrel of 24 months of common law severance. Every single clause in the contract has the power to destroy the whole.
Man. So if you are operating in Ontario in 2026, employment contracts are no longer just simple agreements jotted down on a standard form. There are these incredibly delicate, legally indivisible ecosystems where one wrong word about AI, or literally one missing comma about vacation time, can just detonate an entire corporate balance sheet.
Which raises an important, maybe even provocative question when we look at the shifting power dynamics in severance negotiations.
So what's that?
Well, if we know that the vast majority of legacy corporate contracts out there are technically void because of these hyper-strict 2025 and 2026 rulings, what happens when savvy employees and their lawyers figure this out? Right. Could an employee theoretically weaponize their employer's failure to force their vacation time? Like, they could quietly refuse to take their statutory breaks, secretly building up a technical breach, knowing full well it invalidates their termination clause.
Just to guarantee themselves a massive 24-month common law payout when they're finally ready to leave.
Exactly. The employer's laziness effectively becomes the employee's golden parachute.
Wow. That is a terrifying reality for any executive to mull over as they look at their 2026 balance sheets. Well, thanks for joining us for this deep dive.